The football coach here, Coach Kennedy, actually had been coaching in the school district for many years. And for many years, he had held prayers and given religious talks to the team in the locker room, which was a clear violation of the Establishment Clause and many decisions of the U.S. Supreme Court. And then he would always go to the 50-yard line, the middle of the football field at the conclusion of each game, and pray, and invited students from his team, students from the other team, coaches to pray with him, and often gave religious themed talks afterwards at the 50-yard line. When the school district found out about this, they asked him to stop the locker room talks, which he did, and they asked him to stop praying at the 50-yard line, which he agreed and then disagreed and continued to pray at the 50-yard line. He solicited media. It became a public cause, so to speak, about whether the school district would let the football coach pray. The Supreme Court, well, I guess I should describe the holding, of course. The Supreme Court held that prohibiting the football coach from praying on the 50-yard line after games was a violation of his free exercise rights, and that the Establishment Clause restrictions did not trump the coach's free exercise rights. In doing so, the Supreme Court consciously ignored the way in which the coach had attracted media attention, had consciously put his cause to the public, his press conferences, and so on. It described these as quiet, private prayers. And of course they weren't. Even after he stopped praying in the locker room, he continued to pray publicly on the 50-yard line. So the idea that he was just walking to a quiet corner and giving thanks to God is quite unrealistic and inconsistent with the record in the case. But nevertheless, as often happens, the majority of the Supreme Court had a doctrinal destination in mind, and they weren't going to let the facts get in the way of their journey to that destination. Doctrinally, this is an extremely important case. It removes virtually all of the court's public school prayer decisions and doctrine that had been one of the few areas of Establishment Clause doctrine that had been stable during the last 50 or 60 years. Beginning in the 1960s, the court had held, and had held consistently since then, that prayers and other kinds of worship do not belong in public schools. And the rationale for this is primarily that public school children are mandated to attend the school. They have to attend the school, and they're in a position of vulnerability. They're immature. They're subject to the discipline and control of the teachers, and the opportunity for indirect or psychological coercion for students to participate was extremely high. And so the court simply said, no prayers in public schools. Even if you allow students to voluntarily excuse themselves and leave the classroom or the other place where the prayer was being held. That was insufficient, the court had held in a number of cases, because again, these are immature students. members of minority religion, children who belong to minority religions, would be required to out themselves, in a sense, as members of a minority religion. These prayers were virtually always Christian prayers, and sometimes sectarian Christian prayers. I actually went to elementary school for several years when they had a prayer ceremony. They always said the Lord's Prayer, which of course is Christian, and always read from the King James Bible, which was a problem for Catholics. And the students prayed in a way that was different than I prayed as a Latter-day Saint. I wasn't given an opportunity to excuse myself or to leave. They also never asked me to pray either. So all of these factors led the court to hold consistently from 1960 through the Kennedy case that during school hours in the classroom, while a teacher is on duty, the school could not sponsor, the teacher could not lead a prayer or any other worship service for that matter. That's all gone now. There still is a coercion test as part of the doctrine governing the school prayers in school. But the coercion now has to rise to the level of some sort of direct punishment or penalty. I mean, you can imagine the problems here. A high school football team would have 40 or 50 or 60 members on it. There's intense competition for playing time. And here you have the coach praying at the 50-yard line and welcoming, not requiring, but welcoming players to pray with him. And if you're a kid on the football team, anxious for playing time, anxious to curry favor with your coach, one of the things that you're tempted to do is to pray with him, even if you're not a Christian, or even if you're a Christian, but you normally would not pray or would not feel the need to pray as he does. And this is precisely the sort of thing that the Supreme Court historically had wanted to avoid in the public schools, and now the door is wide open. It seems that a teacher could pray in a classroom during school hours, privately and quietly, in full view of all the students. And if we take the Supreme Court at its word, if students wanted to pray with that teacher, they would be allowed to do so, as long as no student was required, so to speak. And so all the problems of indirect and psychological coercion and social pressure, there doesn't seem to be any doctrine or anything in this opinion that's going to stop that. So under the Establishment Clause, since the early 1970s, we had the Lemon Test, and the Lemon Test has been much criticized. Its demise has been predicted multiple times, and now it's finally arrived. The court abandoned formally the Lemon Test. So the Lemon Test provided that government action has to have a secular purpose, primarily secular effect, and could not entangle church and state, government and religion. Justice O'Connor, when she joined the court in the 1980s, added a gloss to this test that was extremely influential, and that was the endorsement test. So the secular purpose prong, she argued, should be understood to prohibit government from intending subjectively to endorse religion. And the secular effect prong should be understood to prevent the government from doing anything that would objectively appear to an informed observer to endorse religion. So not only is the Lemon test gone, the endorsement test is gone. The court suggests that we should all learn to live together. We should all recognize that we have different religious commitments or no religious commitments. We live in a pluralistic society, and we should exercise tolerance for each other, with which I certainly agree. That's something that very few people in the United States disagree with, and those who do are on the fringes. But when government endorses a particular religion, or when it endorses belief generally, it actually distorts the pluralism and the so-called free marketplace of religious ideas by putting its thumb on the scale of the favored religion, or putting a thumb on the scale of belief generally. I mean, you can imagine the situation, for example, of a Muslim student now in a public school, perhaps in an area where there aren't many Muslims, the American South. Actually, most of the United States doesn't have a lot of Muslims outside of a few urban areas. That student now is put in a very difficult position. And he or she may only be 5 or 6 or 7 years old. I'm not sure it's much better if that person is in middle school or is a teenager in high school, because teenagers, the overwhelming desire of most teenagers is to fit in. And if you're different, now you have to set yourself apart from the Christian majority. It's really an impossible situation and an unfair situation that the government should be exercising its power and influence by endorsing a particular kind of prayer. Since Justice Barrett was elevated to the court several years ago, the court has been making wholesale changes in many areas. And so when it decided to take this case, I had two thoughts. My first thought was, why did they take this case? There's nothing controversial here. The Ninth Circuit got it right, the lower court. This was a case out of Washington, which is in the United States Court of Appeals for the Ninth Circuit. And they held that the football coach was on duty immediately after a game. He had duties, getting the team to the locker room, getting the team on the bus, making sure there weren't fights or arguments between the opposing teams. So he's on duty. He has public school responsibilities, and he's praying in a very public way and encouraging others to pray with him, at least welcoming others to pray with him, even if not affirmatively encouraging him. And so when they took the case, my second thought was, there's nothing, there's no reason to take this case unless you're going to change the law. So I was not surprised that he won, because there was no reason for the court to take the case unless they were going to do what they did, which is dramatically change the law. Now, in a broader sense, this court seems to be very attracted to tests that are rooted in text, history, and tradition. So that, of course, is a major focus of the court in Roe versus Wade. And it was its focus of the court in this case, in the Kennedy case, and in a prior case involving the state of Maine and the payment of tuition, when a teenager who lives in an area, Maine, as you may know, is a very rural state, and there are some students who live in areas that are actually quite far from a public high school. And so Maine has, for many years, paid tuition at private high schools, but it would only pay them, pay the tuition at a school that provided a non-sectarian education. The court struck that down as a violation of free exercise and a discrimination against private religious schools, or at least sectarian, private sectarian religious schools. And at any rate, it wants to look to history and tradition. And if it's really serious about that, you know, the history and tradition of the separation of church and state in the United States barely predates the 1950s. In the 19th century, there were Bible readings in public schools from the King James Bible. And, you know, Catholic students were not excused. They were required to sit there and listen to reading without comment from the King James Bible, which then and now is in tension with Catholic teachings that scripture should be explained by someone in authority. It's a very Protestant idea to say, no, we can read the scriptures and decide for ourselves what they mean. There was prayer in public schools. In the United States, at least, the whole Catholic parochial school system arose in the late 19th century because Catholic leaders grew tired of this insistence that the schools were non-sectarian because they were not associated with any particular Protestant sect, but they were overwhelmingly Protestant. Jews have often had similar problems. The calendar in the United States is a Christian calendar, and not until recently, relatively recently in the 19th century, were Jewish students excused on Jewish high holidays from attending public schools. There are religious symbols everywhere in the United States. The Supreme Court has upheld some of them by arguing that they have acquired a secular meaning, like the Latin cross in the Bladensburg cross case. But now they don't have to do that. Now they can simply say, well, history and tradition allows the recognition of crosses and the Ten Commandments, even in public schools. And the fact that these are symbols that are associated with Christianity or evangelical Protestantism is unimportant. So yes, the broader significance of this case is, I mean, it has huge significance for the Establishment Clause. It's clear that the court sees the Free Exercise Clause as preeminent and the Establishment Clause as subordinate. And apparently, if we take the majority seriously in Kennedy, that free exercise, an individual's free exercise of religion trumps even legitimate fears of the government that it is endorsing religion when it doesn't want to, or that the state is being entangled involuntarily with the church.